So I hope everyone online can hear me, and thank you, Ian, and thank you, Peter, for welcoming us. I too would like to acknowledge the traditional owners of the country on which we are meeting today, and of all traditional owners of the lands across Australia from where our guests online are meeting. I acknowledge and pay respects to the traditional custodians of this country, of Wurundjeri, Woiwurrung, Bunurong, Boonwurrung peoples of the Kulin Nation, and pay respect to their elders past and present, and respect the fact that many maintain that the sovereignty which has passed has never been ceded. Today we're going to hear from some wonderful panel members, Monica Morgan, Mihi Yarangi Piripi from Aotearoa, New Zealand, and Arnold Bloch-Leibler's Special Counsel, Bridget Cowling, on how charity law responds to First Peoples organisations, First Peoples charities, and some of the issues for First Peoples in Australia. So the first two speakers, Mihi Yarangi, who I will call Mihi from after this because it's just a bit quicker, and Monica will introduce some of the barriers and experiences they've experienced in sociological constructs of good governance for First Peoples organisations. We heard some really interesting perspectives on the ORIC experience and also from charities services in New Zealand yesterday at the ACNC conference. And I'll be very interested to hear from Mihi about the New Zealand experience as a lawyer practicing there. My first pleasant duty is to introduce Monica Morgan. Monica has been described to me as a passionate activist, a force of nature, and a wonderful person of will and fortitude. Monica is the highly regarded CEO of the Yorta Yorta Aboriginal Corporation. I am a bit caught out because I didn't print. We have a kind of no print policy at Oxfam, so I've got soft copy, long bios, but I might just allow the time to be used for your talks rather than outline your background. But I do want to acknowledge your role as a CEO in that community and the work that you've done towards the Barma agreement and your role up in Barma now. Mihi is the Managing Director of Wahia Legal in New Zealand and also has had a practice in Australia in her earlier career, but now is regarded as a go-to person on First Peoples or Maori law in New Zealand. Arnold Bloch-Leibler's Bridget Cowling has an established practice in working with traditional owners and First Peoples in Australia. So I hope you'll enjoy this talk. The process we're going to follow is to hear from each speaker. We have about 10 minutes each. We might reserve questions, if that's all right, until the end of the talk. Thank you, Caitlin, for monitoring the Q&A. There is an opportunity for questions to be posted for online participants. So at the end of the session, I'll just take questions from the room, but also we'll cut to Caitlin to see if there's any questions there. And Dylan, thank you for your help. Dylan from Arnold Bloch-Leibler is assisting with any technological issues. So without further ado, I might invite Monica to lead us off with your reflections today.
Can I stand?
You can, and or the podium. Yeah, and where's that one?
Thank you very much for the welcome, Peter, my long time friend and associate, supporter of Yorta Yorta people. Thank you. And Maria Mahara Rang, I absolutely thank you for coming to my country and this land here, the Kulin Nation. So we're here to talk about charity regulations. I grew up as a charity, so it's a really it's a funny notion, you know, you're a charity case. So we grew up very poor on country and used to being under very many acts and conditions and processes. So today I just want to reflect a little bit. I want to give recognition of the Wurundjeri people, the Kulin Nation. And I also want us to understand that under all this concrete is their country. And that street of called Elizabeth Street now was the most beautiful creek that run down to the Yarra. So you can imagine the most beautiful country, and this was. And it was a place that Yorta Yorta people came to in the early 1800s. All the nations of around southeastern Australia came together and laid down our sacred sacred objects of law to say we will put them down for future. So this place is very special for all of us. And having said that I do not call myself an Australian. I haven't got my language, but I don't call myself an Australian. I'm a Yorta Yorta. I'm a First Nation person from this country, First Peoples. And this is an imposed process on me and my people. So the recognition needs to be very clearly about that. I remember having a yarn to Ron Caston, had me, remember Peter, to talk to a group of students, and they said, how do you feel as being Australian? I said, I'm not. But we exist under a blanket, and it was very well spoken about in our native title application by one of the young people, Darren, and he talked about it's like we've got a blanket over us. It's like we've had to lay our sacred objects down until there becomes a time that we can come out, because at the moment we're living in a shadow. So I know we're under, so the Yorta Yorta Nation is actually under a CAATZ Act, and it's a Commonwealth Act of specifically for Aboriginal and Torres Strait Islander peoples. It has an element of capacity, but very little in relation to charity. It's more an economically, you're really, you mostly have to report on your finances. That is your call. How large and small your finance stream is makes you a small or a large organisation. It was some time, I think 2009 or something, that Yorta Yorta actually put an application in to become a charitable institution. Mainly for us, we were looking at a way of getting donations and things from external in that process, and we tried to put ourselves under environment because there was no real process in there. There's no process for First Nations, so we are primarily here, the Yorta Yorta, to look after country, to look after the water, to look after our sacred sites, to look after our dreaming places. So that's the fundamental operation. So as you're trying to fit within a structure that really dominates you and oversees you in economic sense about how well you look after your money and how well you perform your governance rules under there, it's a very difficult process for us because we've got a family group structure, a very strong family group structure. So our ancestors, what's left of them after the massacres, the rapes, the murders, and the stealing of our country, is that we ended up with 10 ancestors. Out of those 10 ancestors, we have 16 family groups. And those 16 family groups have a council of elders, and they are the authority for a country. They're authority about what we say and do. So how do you fit them within a white colonial construct? It's a very difficult process. It's something that we battle with every day, and it's exactly what Peter was saying. We live within a black world, but we have to meet in a white world. So it's kind of our vessel for that process, and that's how we see it. When I was younger in the 70s, we formed our own tribal council. I mean, the elders formed a tribal council, but you couldn't, you can't legislate, or you can't get into under a tribal council with the laws that you have. So our sovereign laws and who we are and how we abide with each other and how we communicate with each other every day. I live on an Aboriginal ex-reserve, but it's actually country that our mob put a petition in. 1% of our country is Crown land, and a portion is country that we have land that of my people. I'd rather live with my own people than buy white land, right? Land off white people. This is my land. So I think the fundamental thing that you've got to understand when you're speaking to Aboriginal people, and particularly First Nations people, I don't even like the term Aboriginal because it's a construct as well, but everything we do is English, is that we have our own systems, and that you're not coming in and being benevolent and saying, here, we'll help you. What you do is you say to us, what do you need to get what you need to happen within this white system to progress the rights of your people? And that rights of the people might also mean, keeping our people out of jail, keeping our people from being killed in custody, keeping our people out of the mental institutions and the health system. Those are the kind of things, but we don't want to be doing it on a charity base or a paternalistic level. It's really about how you approach, how you come to the leaders and how you come in and recognise that when you're stepping on our country, you're stepping on our country and that you're the visitor. Because our elders for so long have been come through a whole paternalistic process, a colonisation process. And finally, I just want to say, we don't support the Treaty of the Heart. I don't support any constitutional change within the system. It's all created by men. It's all created by Anglo men. There was no women involved in the Constitution. There was absolutely no First Nations involved in the Constitution. The whole thing needs to be scrapped from the start and recommenced. That's the only way. You can't tinker with things. All you're doing is adding on layers within a system that's already set out, a colonial system to talk about land distribution and states. And I had a wonderful ancestor, William Cooper, who did a day of mourning and also did a day of mourning in what was the Australian 150th year celebration of Captain Cook. There he said, we need to have people in a new system, but we need to have our people inside the system, but similar to how the Maori people have it. It's chosen by our mob on the ground in the system as a separate process, not as an advisory, somehow clawing your way inside and knocking on the door. That is not our old people said at all. So I just wanted to say strength is in change, strength is in the way you approach us, and its strength is in giving us the ability to be in control of ourselves. Thank you.
Thank you, Monica, and I'm sure there's 100 questions now, but if you could hold them and we'll come back to those. Mihi, please do speak. Yeah. I think they should be.
Oh, yeah.
So for Pete.
Can I sit over there and look at the slides?
Yes.
What people are seeing at home is not necessarily what you're seeing on the screen. So you just focus on what you're seeing, and people are seeing different things at home. So you know.
Thank you to those on the webinar. Rich has just explained that you'll see something different to what we're seeing in the room.
I aku nui, I aku rahi tēnā koutou katoa. Ki te whare e tūnei tēnā koe, ki te whenua, e takatona i tēnā koe, e te māreikora Monica, tēnā koe. E rere nei ngā mihi kia koutou katoa kua tai mai I runga I tēnei kaupapa. Ko ai e tūnei, ko mihi arangi piripi tōku ingoa. Ko whangatawatia te maunga, ko tinana te waka, ko kāriri kura te moana, ko roma te marae. ko te raroa kaiwhare e tuatu nei, tēnā tātou katoa. Thank you, and I think I've got the hardest job today going after Monica after that kōrero. My name is Mihi Arangi Piripi, and I'm a Māori legal practitioner practicing in Aotearoa, New Zealand. I also had the pleasure and honour of working for a number of years with traditional owner groups, predominantly in Western Australia. A few caveats in my kōrero is that it's very much comes from my experience as a legal practitioner and as a Māori person, and acknowledging that while there are many similarities, that it's, you know, our cultures are quite different as between Māori and Indigenous cultures here. I wanted to talk today, so much of my work, both in Australia and in New Zealand, has been with Indigenous organisations, and so I wanted to talk about what are the common features, what are the things that make Indigenous organisations different. And some of them Monica touched on. We are essentially whakapapa based. Whakapapa is, might need an entire hour session on what whakapapa is, but essentially familial, you know, Monica talked about apical ancestors, but tipuna based. In New Zealand we have hapu and iwi based organisations. So that brings, you know, quite a different dynamic to an organisation when it essentially is a familial or whakapapa based organisation. Expectation. The expectation on particularly settlement PBCs or post-settlement governance entities in New Zealand are huge. The expectation in both internally and externally. The expectation from internally from members in relation to social issues, cultural issues, commercial performance, environmental obligations. I really don't, you know, I think there's a reason why I'm an advisor as opposed to somebody that actually has to sit on the likes of a PBC or post-settlement governance entity. The burden is really heavy. And realistically, it's so difficult for an organisation to do all of those things. And so many have to choose between what the focus areas are and manage expectations. Need. You know, I think this is quite an obvious one, but there is a huge need. I saw a statistic just in the news a few days ago in New Zealand that 65% of our women population are Māori women in New Zealand. We only make up 16% of the population. It's actually less for Māori men, but we are overrepresented in prisons. We've got high unemployment rates. We've got high domestic violence rates. We've got high suicide rates, and we've got high addiction rates. So there is an obvious need. Political element. So Indigenous organisations are often having to politically advocate. And what does that mean? The pressures of settling, whether it be a treaty settlement or whether it be negotiating Indigenous land use agreements. Distrust. So I think this is both internally and externally. So particularly in New Zealand, there is a huge distrust of governments, and then even internally there can be distrust. And a lot of that is just I think, you know, intergenerational trauma and colonisation of things that have happened that you end up with distrust, which makes it really difficult from a governance perspective in an Indigenous organisation. Capability and resourcing. So this is getting better in New Zealand, but I reflect on perhaps 5 years ago when we recruited, or perhaps a bit longer, 7 years ago perhaps, when we recruited for a native title lawyer in Perth. 40 or so wonderful applicants, one of them Aboriginal. You just don't have the capability, and there needs to be a shift. There are now many Māori lawyers, accountants, and experts in New Zealand, still not enough, but but certainly not enough here. And law versus law, so Monica talked about this two system. You're trying to work within a system that's not designed or created for you. I have great respect for the law and tikanga systems of Indigenous people here, and obviously also New Zealand. We now have in New Zealand the evolution of tikanga within our law, which is creating, again, probably another whole lecture on, but is creating some interesting discussions around how it needs to be incorporated into the law and whether that's appropriate or not. So in terms of what that means from a governance perspective, I think for Indigenous organisations, in Aotearoa we don't have a CATSI Act. We do have Te Ture Whenua Māori Act, which is really about Māori land. So it's a different tenure for land that is Māori land. We've got the Māori Fisheries Act, which is for fishery settlements, and there is a governance framework in that mandated iwi organisations must meet. We also have the Māori Authority regime, which Australia doesn't have. So it's a 17.5% tax rate for qualifying entities as Māori authorities. So it's not about, they're not charities, but they are Māori authorities on the basis that the ultimate beneficiaries would have a lower marginal tax rate, and therefore the rate is 17.5%. But otherwise, like you're doing here, we're doing our best to work within a system that wasn't actually designed for Māori entities. And so we're just tinkering around the edges of how do we fit within the system. And so the things that affects are things like decision making, both from a either director or trustees perspective, but a member's perspective. What is traditional decision making? Like, was it holding an AGM and everybody having a vote? In terms of trustees making decisions, is it consensus? Is it this idea of majority vote? I held a session not long ago with a group, and someone challenged me, rightly so, because I think we're so used to elections, and they said elections aren't the Māori way of doing things. Like, why do we do elections? And we do them so much in New Zealand. And it was a great question, because I thought, and how do you balance that with robust systems and transparency and accountability, but also ensure that things are done in a culturally appropriate way? Composition of directors and trustees is always a really interesting one, and many of our various clients do this in a different way. Monica talked about the likes of elders councils and groups and things like that. But many of our clients struggle with this idea of who's best to represent or to act as the group of trustees or directors. Should there be things like gender equality, rangatahi, so age? Should there be requirements that people are knowledgeable of the law or have been through the law, or can speak te reo Māori or understand tikanga? And so ensuring that the right people are qualified to govern an Indigenous organisation. Conflicts of interest, which I think I had a comment a few weeks ago from a client who told me, if I have a vested interest that this works for my mokopuna, and that's a conflict of interest, then yes, I do. And so that kind of relates back to that whakapapa point. What might be a conflict of interest for an Indigenous organisation is quite different because of all of those elements. And dispute resolution. So we're constantly, when we are assisting, establishing or changing or reviewing trust deeds or rule books, we're constantly changing the dispute resolution processes because they need to reflect how disputes need to be resolved from an Indigenous perspective. So, and that's not the same for every group. And so I think, a lot of ours are, we do things like the establishment of disputes committee that might need to include an expert on law or tikanga or culture, increased kind of mediatory processes, ensuring that people come together face to face. So there are a range of ways we can tinker around the edges. But one of our biggest queries we get from many of our clients is, we want a trust deed or a rule book or a constitution that is as Māori as we can get. And we're still trying to fit it into these constructs because we don't, you know, we're within the system. So what can be done? I've heard it a little bit today around the concept that the answer lies within Indigenous peoples, and that's something that I really strongly believe in. We've got to recognise rangatiratanga, and rangatiratanga from a Māori perspective loosely translates to sovereignty, but you know there is no English translation. But you need to, like in my view, the answer lies within Indigenous people. They know, and they should. It shouldn't just be about working with them. They should lead what the solutions are. And in New Zealand, there are lots of, at the moment, by Māori, for Māori solutions, but it has to be genuinely by Indigenous people. One thing that I struggled with during my time here, working with Indigenous groups, was you know, the establishment of benefit management structures, and the fact that stakeholders, which in many cases were mining companies in that regard, had a say over the benefit management structures. Those structures are the structure that people receive, you know, it might be mining benefits for mining on their country, and you've got an external stakeholder like a mining company dictating how that should be run. Like, I just found that hugely offensive. Law reform, although I think we need to be really careful, because law reform, Indigenous people might not want their tikanga or their law translated into a Western legal system. And so I think we need to be mindful of that. Monica touched on it. We're now dealing with it from a tikanga and the law perspective. Is it right? What's the danger of judges in a Westminster system applying our tikanga and our law? So I don't think it's as simple as law reform. I think there needs to be discussion and thought about how that's done. One thing I think is really important too is letting there be mistakes and learnings. Non-Indigenous organisations get the chance to do this all the time, but it seems like Indigenous organisations that never get the chance to make mistakes and learn from them. And culturally appropriate training. Many of our clients, we do governance training with them, and many of them say they go to kind of broader training, and a lot of it's not culturally appropriate. And so I think there is a space for culturally appropriate training for Indigenous organisations. I think that was me. No idea how I've gone for time, so.
Thank you, Mihi. You're keeping us well to time as well.
I stand up here, even though I completely set it up differently. And that works.
Yeah.
So I'm just messing with the whole setup that I made everyone achieve.
Thanks, Mihi. Well, we're now hearing from Bridget Cowling. Her talk is on, after 10 years of the ACNC, the CATSI Act has some catching up to do. Thank you.
Hi, everybody. And my goodness, thank you so much, Monica and Mihi Arangi. It's just the biggest honour to be on the panel with you two. I stand here as a non-Indigenous woman. It's really important to acknowledge that up front. So I stand here as support crew, completely supporting everything that was said, and it dovetails so well into what I'm hoping to offer to you today, which is a comparison between what we do have, that blanket, as Monica described it, one of those blankets that have been placed over traditional law and custom. How is that working? And is there something we can learn 10 years on from the ACNC. So from the governance standards system in particular. So my perspective is an outsider and advisor, but I hope it offers something. I'm just going to get these slides to click, maybe. Oh, okay, now it's going to, yeah, I knew that would happen. So my presentation has a particular focus on the CLAANZ Act, which, as we've heard, and we heard from the regulator yesterday from the registrar, it's a unique piece of legislation providing for incorporation of Aboriginal and Torres Strait Islander peoples. And I'm particularly interested in its ability to provide flexibility of governance, because one thing that's come loud and clear from Monica and from Mihi is we need flexibility. There is not one way of doing things in Aboriginal culture and in First Nations tradition at all. So can we get that flexibility? This is what I'm going to look at. First, a bit of context about the CLAANZ Act, and then how does it approach flexibility? I'm going to look at then what is on offer for charitable companies limited by guarantee under ASIC. What can we learn there? And then just some where to from here. So we're starting with context. Aboriginal and Torres Strait Islander people obviously can choose to incorporate under CLAANZ, and ordinarily they can also choose to incorporate under any other state and territory legislation in Australia. What might surprise some of you is that that's not always the case. The CLAANZ Act is mandated. That choice is removed in particular situations. One of those is if you're holding and managing native title. So a registered native title body corporate has to be CLAANZ. There's also certain federal government funding that mandates CLAANZ. So that choice is removed sometimes. CLAANZ corporations are as diverse as any corporation that you might expect. There are fewer than 250 that hold native title, but there are service providers that are the lifeblood of communities, urban, rural, remote, doesn't matter. Land management, economic development, and that's what we heard from Monica. That's an important one for CLAANZ corporations. Can include for-profit, but that's not very common. And because we're at a charity conference, there are about a third of the CLAANZ corporations that are registered charities. Next part of the context here, and what you're seeing on the slide, is really a potted history of the development of the CLAANZ Act, which provides the context for today's discussion of flexibility. So it was about 50 years ago that Justice Woodward, in his seminal report, highlighted that what Australia needed was a flexible system of incorporation that accounts for the unique culturally informed governance arrangements of Aboriginal people. What we got from that was the Aboriginal Councils and Associations Act. That was the first piece of legislation in '76, and it really embedded flexibility, but it had a real failing, and Mihi absolutely expressed what that failing was in her presentation just now. It allowed the registrar to judge the appropriateness of Aboriginal and Torres Strait Islander custom, because the registrar would decide whether the customs that had been written into any constitution were appropriate. And that was an issue. Over the next 30 years, I'm not going through every detail on that slide, for reasons that I think are largely centred on using non-Indigenous governance ideas as the norm for good governance. Instead of maintaining that flexibility, what we got was increasing complexity. We got extra governance, extra complexity, till we ended up with, in 2006, the CLAANZ Act. I'll give you that slide later. So the CLAANZ Act, it tried to stick with this original idea from Justice Woodward, and its explanatory memorandum says it's a strong but flexible legislative framework that maximises alignment with the Corporations Act, but provides sufficient flexibility for corporations to accommodate specific cultural practices. According to its preamble, it's a special measure for the purposes of the RDA. Now, to be a special measure, there are many ways that the CLAANZ Act deals with that. I'm obviously not critiquing the whole Act today, but I want to look at how the CLAANZ Act provides its professed flexibility. There are four main mechanisms that CLAANZ uses for flexibility. It uses, firstly, replaceable rules. That's familiar. The list of replaceable rules in the CLAANZ Act is not materially different from the list in the Corporations Act. It's a bit of that tinkering around the edges. It uses exemptable provisions. It has a series of exemptable provisions where the permission of the registrar can be sought and received to be exempted from some of the requirements of the legislation. This process is bureaucratic, and it involves an unsatisfactory power dynamic that, again, we can talk about at question time, but it was certainly touched on by Peter at the very start in his acknowledgement of country. There's differentiation in obligation based on size, as Monica touched upon, also familiar in the Corporations Act. What is unique about CAATSI is its regulatory approach. So the Act requires, I've given you the section, that in performing her functions, the Registrar must have regard to Aboriginal and Torres Strait Islander tradition and circumstances and administer laws with a minimum of procedural requirements. Okay, so that's something, that's good. And I will not cavil to say that the Registrar and the team at ORIC do work really, really hard within the constraints of their legislation to be supportive and helpful and to live that. But overall, the picture that we have is a piece of legislation that doesn't offer a great deal by way of truly flexible governance. And you didn't need me to go through all of that really, because Monica said exactly that at the start of her presentation, or the middle, or at some point. So my purpose really is to say what's happening with charitable companies limited by guarantee. They already have replaceable rules. They already have differentiation based on size. What is new is that registered charities have section 111L of the Corporations Act, which switches off a whole bunch of the requirements for meetings, of the requirements for notice, of the requirements for reporting, and of directors' duties, which I'm not going to go into today. So what we have now is charitable companies limited by guarantee just have to comply with the governance standards. They're not fixed rules. Governance standard 2, you must be accountable to your members. Mihi's already talked to you about so many different ways in New Zealand that an organisation might choose to be accountable to their members, not following the standard democratic processes of meetings. Companies limited by guarantee that the charities don't have to have meetings. So what we can see here is that charitable companies limited by guarantee have much more scope for flexibility and a tailored approach to governance than CAATSI corporations. So my last slide, what does this mean? Where to from here? So we could continue with the iterative changes and increased complexity. Monica touched on that, on how laws have just increasingly added and added. The NIAA recently conducted a thorough review of the CAATSI Act, and an amendment bill passed the House of Reps before the change of government. That bill was another iterative approach. There were no fundamental governance shifts. There was some good tinkering, I'm not going to say there wasn't, but it wasn't fundamental. If we continue down that path, that's the same path we've been on since 1976. We could introduce the equivalent to section 111L of the CAATSI Act, or we could move to more comprehensive principle-based governance. So I've got a question mark over some thoughts about that and some considerations. The 2017 technical review of the CAATSI Act rejected a shift to principle-based governance. Again, in question time, if there's time, we can go into why I'm not convinced by any of their reasons. And I think they overall equate again to thinking that good governance means non-Indigenous ideas of what is good governance. Those of you in the room, I know I can see some of you, and I know Rosemary Langford online, are going to jump up and say, quite rightly, if we want to do switching off parts of the CAATSI Act, section 111L is not a cakewalk. It's caused all sorts of technical problems. But we're working through those. And in every discussion I've been in that says, okay, section 111L is not really working, not one practitioner and not one charity has said, let's just put it back on. Let's just go back to the way things were and have all charitable companies limited by guarantee completely regulated by the Corps Act. It's not what we're wanting to do for non-Indigenous corporations, so we shouldn't be afraid to move forward for Indigenous corporations. And it's also important to acknowledge that there's a diversity across the country in how people feel about the CAATSI Act and in what people think the solutions are. As both Mihi and Monica and Peter in his acknowledgement of country said, this has to come first from an Indigenous-led position. So all I'm here to do today is offer what I think is another model that should be explored further, and I suppose just my own view for consideration. And that's really summed up here in the third box. If we recall the history of the CAATSI Act and its own explanatory memorandum, and if we think about Article 18 of the UN Declaration on the Rights of Indigenous People, then the CAATSI Act should account for the unique culturally informed governance arrangements of Aboriginal and Torres Strait Islander people. It just has to. What we have is a CAATSI Act that provides less flexibility than charitable companies limited by guarantee. So my offering today is that I think it's time to fundamentally revisit the CAATSI Act's approach to governance. Thank you.
Well, thank you, Bridget, Mihi and Monica. What a privilege to hear your different perspectives. As a panel chair, it was very interesting to sort of listen to your themes of the evolving context and the challenge to us as charity lawyers, or there might be a few accountants in the room here and also across the Tasman. I know we have friends in New Zealand listening, to understand how we can respond to the question or suggestion we heard Monica express, which was not here, we're going to fix it all for you in our Western construct, but what do you need from us to perhaps do this in a different way, to assist you, to be a good ally and to enable you with our particular ability to contribute, and that's from a charity law or legal academic practitioner, legal academic perspective. So we have the room of people who are most likely to be working with Indigenous organisations or organisations that work with First Peoples or Maori peoples, and I'd be interested to know if any of you have questions. We have one from the back. And also I will come to our online listeners shortly. Thank you. So I see Matthew Turner and then Anne Robinson.
Thank you for the presentation, Matthew Turner. I've done a little bit of thinking around this myself, Bridget. British law prior to Henry VIII recognised unincorporated associations. 15 states of the United States have now passed legislation recognising unincorporated associations. The European Court of Justice recognises unincorporated associations, and it wouldn't be too difficult for Australia to pass a fairly basic piece of legislation that recognised unincorporated associations. And once you get that, what they do is they give legal personality to unincorporated groups, which would take us a long way, I suspect, to where Monica would like to go without having to work through the Cats Act and further amendments. So it's just a thought that I'd put out there in case it's helpful to people.
Thank you, Matthew. And I might ask the panel if anyone would like to respond before we go to Anne.
Yeah, I had to give advice recently to a group, and they had an unincorporated group they used already, and they wanted to retain that function, notwithstanding they had to set up a legal entity to receive funding, government funding. But their response was, and it freaked me out as a lawyer, because I'm like, well, do they have a terms of reference? What are the rules? Like, how do they? And they said, like, look, we want it to have that flexibility. Like, yes, it will change. Yes, there are no rules around who comes in and who. Well, there are rules, but they're not written in a terms of reference. And so in that way, so how I did it in that way was we retained the unincorporated group as a group that then had power within a trustee to make decisions and to refer back to things. So that was kind of the way we got around it. But absolutely, sometimes in New Zealand we've got the Iwi Chairs Forum, which is a group of all of the chairpersons of iwis in New Zealand. That is an unincorporated group that holds a lot of clout, that meets regularly, that provides advice and makes submissions and the like, and they're unincorporated. So yeah, I think absolutely that there is a space for unincorporated entities.
He's looking at me, so I'll just go, absolutely. What I've given you is an example of what's available at the moment. I haven't thought about that example. It's a good one. We need any examples, I think, that take us off this trajectory since 1976 of just adding and tinkering and adding and tinkering. So yeah, thanks, Matthew. Great contribution. Monica, anything on that one?
No, I'll leave that one.
Thank you. I think that was an inspired suggestion. Thanks, Matthew. And now to Anne, and then we have a question from Jennifer Baird.
Thanks so much. It's really helpful. Look, I have just two reflections and a question, if I could. One is, I think that the standards-based regime of the AEST regime has actually been quite powerful if you don't go into it with preconceptions. So I sat down with elders in Central Australia amongst a number of language groups there, and the governance, I didn't do the governance training, but walked alongside elders who are working out how to do that, and to do that properly in language and working out how do you, because the standards require how you demonstrate you met stuff. It doesn't say you have to do it in a cultural way. So I think there's quite a lot of, and I'm sure you're doing that, which is really good to hear in terms of proper in governance training. But the point I'm interested that Matthew raised that issue around unincorporated associations, because when you think of it, before the ACNC regime came, before the Corporations Act was a thing, one of the principles of the law in our space is that the law has no jurisdiction over the activities of the sort of organisations we're talking about. And we've got a vestige of that in the tax law consideration for basic religious charities, which is these are things that the law has no jurisdiction over until you're dealing with property disputes. And all the state jurisdictions, the state Supreme Courts said very clearly, and it's binding law today, that the state has no jurisdiction over the internal workings, governance workings of unincorporated bodies. Whether it's not just religious, obviously religious was one of the key pressure points, but it relates to any unincorporated body, and the state has only jurisdiction when it comes to property disputes. The courts are very clear. So one of the constitutional dilemmas, actually, we don't want to talk about the elephant in the room, about the constitutional validity of the whole ACNC regime.
Was that the elephant?
We were thinking of the Constitution itself.
The federal government has, even legislating in this space. And I think there's a whole lot of room. I like Matthew's idea of maybe having a statutory. You've got to give bodies the tools to operate in a modern society. The dilemma that's led to incorporation has been you've got to be able to contract, you've got to be able to receive money and all that sort of thing. So it's been about the property that has been the dilemma. But if we could come up with a better idea, and I like Matthew's thought, I think it's quite novel and a bit counterintuitive that you can incorporate an unincorporated body, but I just think we need to look at, there are other ideas there, and they're bodies that have been historically disempowered and need protection and freedoms. We have that language, so why can't we apply it?
Thank you, Anne.
Can I make a small comment on
Yeah.
that? I just think it shows, this is a bit of a flippant comment, but it just shows our priorities. First property, then religion, then law, and then let's look at Aboriginal law and custom, see where that fits. That's a problem.
Jenna, would Mihi or Monica care to respond on that?
Did you have anything to add? No, a couple of comments I noted. Like I note that, and it's been a while since I've practiced in Australia, but PBCs are required, so they couldn't then fall within that carve out there. Another thing you talked about was around the standards and how there's flexibility. My question is, who created the standards? Because that's the whole problem. The framework is not created by Indigenous people, notwithstanding the fact that there's flexibility, but that is precisely the problem. Yeah, so that's kind of my card on that.
Thank you, Mihi, and I want to recall the remark that Monica shared with us about the focus of the legislation, particularly the regulation of CATSI organisations and their origins in economic and financial reporting, rather than the social and cultural and how the organisations go about. So, fantastic question, Anne, and thank you for raising those comments. I think it's like it's out of these conversations with each other as a profession that we can start to spark ways forward.
Can I also say that with the CATSI Act, they only have one way. So if there's because there's undoubtedly all the time, and it disputes family process because it's so rigid in how you can exercise your rights through membership. We try and do the 16 family groups, and the 16 family groups put somebody up who then goes on a board of directors. But of course, it's not all those family groups. So there's lots of disputes. So when you go to the CATSI, the only one way out, if there's governance or issues, is to go under administration. I mean,
Mm.
that's their only outer. And of course, that's the last thing that you
Mm.
want. So you try your best to try and navigate internally without saying too much, because they're like the mission. You know, there's some really wonderful people in there trying to do the best, but it's like an overlord, and you want to say very little to your overlord because you don't want to let them know too much about what's going on, other than giving them your financials. And so the system itself it's the whole system. It's the system. It's not there for us. And of course, we want to be able to hold money, but we we also want to have a correct say about how we distribute the power amongst ourselves. And it doesn't allow for that because it's so rigid in its formulation, because it's from a white fella's perspective, not from our perspective. And, you know, and I can only imagine how hard it is with, because we also, so we might say family group, but we also got clans, you know, that belong to particular areas of country. You know, that becomes very problematic, not problematic, and how to fit it within that system. And so, yeah, it just is.
And can I just say that actually non-Indigenous organisations might learn from better ways of doing things from Indigenous organisations. Like, we're talking about just Indigenous organisations having different governance, but actually you see it already in New Zealand, some of the ways that Māori organisations would work for a non-Indigenous organisation, because sometimes it's a better way to do it. But there needs to be the space to have a discussion about, is that a better way to do it? And a mind shift of, you know, it's exactly that, it comes from the wrong one. Yeah.
So interesting to hear stories from standing in both your shoes. I'm really conscious we have a couple of questions, and so to give the opportunity for other people to hear from you as well. Jennifer Baird, and I can't see who's at the back, but there's a question at the back, and I'm Caitlin. Any online? Okay, thank you, Jennifer.
Thank you. Great to see an all-women panel. And Monica, I'd just like to offer my condolences for the death of Veronica Nelson. It's terrible.
We lost 2 Yoriora women within 5 years.
I'm really sorry. It was just a abhorrent way to be left to die in custody. Monica, my question is...
And your day too. In the cell.
Many calls for help.
Thank you. Thank you.
I have 3 kids, and they've got a lot of work to do in this space. And I'm just wondering, there's been a lot of talk here still in this room about white law around a topic that is essentially about regulating property, private property, and capitalism and money. So you talked earlier about not wanting to work with the current constitution, but starting from scratch. But in addition to the constitution, obviously you're working with a system of capitalism that was also imposed on you. And I was really interested in what you already have said about having to work within those systems and how they fit with kinship systems and clans and so forth. But given the choice, if you're living in this capitalist system and you're obtaining the profits from your country, in your view, do you need all of these settler laws to help you regulate and account for those profits? Or is that a question of sovereignty that you could regulate your own profits?
It's about distribution of wealth. But money in itself, it's us having to, we're a provider to the non-Indigenous world. We've got to give information to the government. We're basically there to any wonderful programs that they think they're bringing in, somehow we've got to be accountable to those programs. And it's really about us being the payment for us is working with the government most of the time. It's not really about us obtaining money for land and for those things. There has been a shift in just recently where we've been able to acquire joint management over country, but we don't own that country, but it's joint management, and we've got some funds to be able to develop cultural centres and a Bush University type process. So there's some good things, but when you look at the wealth and the tax and the consideration of what's coming for First Nations people, it's always around having to do your submissions, to answer the call, to fit in with the framework, and not as a part of what is the wealth of our country and what is the wealth that's been lost for our people, not being able to hold our country. And wealth is not just monetary. Wealth is about living and looking after our people and providing for our people. So it's always on a benevolence. So that's why I was saying we're always like a charity. We have to reach out and say, oh, we need this because of this. This is all the justification. So it becomes really difficult, yes, yeah. But with sovereignty itself, I don't think the concept is, I mean, it's a wide concept and it comes from kings and all that kind of stuff. But the process around it is that we self-govern within our own selves. So there needs to be some kind of constitutional change to recognise that First Nations people exist within their own, exist within country, and we're kind of like our own Shire council type process. Like, you know, the distribution of land and wealth needs to be readjusted, but also about how areas of country and how we look after each other is simply more like a looking after within a land area. So it's very different than what you're seeing. And look, bringing in a company guarantee, it's no different. It's, you know, apples and oranges, you know, kind of thing, what you're talking about. It's really about the fundamentals of it. Yeah.
Thank you, Monica. I think there is one more question, and
maybe we should finish.
Yeah.
Yeah.
So we have one question. If it, perhaps we could take that one on notice. So I'm very sorry, we're going to conclude just a couple of minutes early.
Sorry.
So,
With I just want to know.
Now?
well, I would like to take the no.
I just want to know who the minister was. I had no idea.
I love that. I don't know about other listeners in the room and online, but that was one of the most interesting and thought-provoking panels, if not the most interesting and thought-provoking panel sessions. I love the idea of a plurality of systems and constructs and concepts that really recognise and acknowledge and provide authoritative place for First Peoples in Australia, and fantastic to hear Mihi's perspective of, well, you know, the progress, but also the areas for improvement in New Zealand. It's such a generous sharing of your perspectives. Bridget, I'm always interested to hear from you. Throw it up in the air. Let's do something if we can just keep making progress. So I really do want to thank you all on behalf of people here today. Thank you.